I opened up with the line of, you're not going to like my client. You're not going to like what you see. You're not going to like anything that you hear the day at the hospital. You're not. You're not going to like it. But that doesn't mean that the state was proved their case. Also, the hospital was told by the police that you can't tell these parents that their child is dead because they want to hopefully get them to keep talking to them. I mean, if they're hopeful, then they'll talk to the police to talk about what's going on because they're so hopeful that the child is going to be resuscitated. And so law enforcement actually told medical personnel to not tell them their child had actually died a couple hours before while they're interviewing both these parents.
Is that proper?
One of the things the prosecutor did that really rubbed me the wrong way is she had all these text messages, and the dad and the grandfather were charged with tampering with evidence. And so she knew all this and still said when she went through the text messages that were sent by dad on body camera and said it was in fact this defendant that sent them. Like, she was essentially lying intentionally to the jury, saying, I guess was just hopeful that I wouldn't call that officer to come show that was complete bullshit. And that was the one thing that really pissed me off about how the state handled the case.
Yeah, you had to go after her credibility at that point.
I think as defense attorneys, we had to be very cognizant of how we do everything. It doesn't matter of how small the detail is. We have to maintain that credibility holistically throughout the case.
We don't get a pass. We don't get a pass like the prosecutors did.
Exactly. We don't get a pass. With this client, with the death of the baby, we couldn't have asked for a better set of people to come forward for our client.
Today I want to talk about a case that involved a mom who was charged in the death of her infant child that occurred as a result of fentanyl overdose. Today's guest is attorney Ryan Michael Kreck. Did I pronounce that right?
Kreck, yeah, correct.
Correct, but Kreck. Ryan Michael Kreck. Before we dive into the case, let's get to know a little bit about Ryan. So Ryan, tell us what inspired you to pursue a career in criminal defense?
I think going through law school, one, it was my best grade, and two, I didn't necessarily set out to do criminal defense in law school, but I kind of grew to it in law school, and looking back and kind of analyzing why I've gravitated to it. I think I've always been the guy that kind of stood by people, whether they're in bullied in class or anything like that. Like, I had a story where in fourth grade, we're in Lubbock, Texas, and we're polling who's going to win the Super Bowl between the Cowboys and the Buffalo Bills. And one kid, my friend, said Buffalo Bills is the only kid up to that point to say it. Everybody dogged him, yelled at him, and I changed my vote from Cowboys just to the Bills just to be by his side. Of course, everybody else was right. The Cowboys won, but I don't know. It's just kind of who I am. I like standing by people. I love representing individuals. I've never been a prosecutor.
Where did you grow up?
I grew up in West Texas, in Lubbock, so in the Panhandle. It's very flat. It's a great place. Not big city life, but the people are very nice. But if you do them wrong, they handle things honorably. I know it kind of sounds cliche, but it is very nice people that are understanding. But if you do something wrong, there's still a sense of justice there, a sense of right and wrong that's pretty strong in the community.
And you practice now in Lubbock or in that area?
No, I practice in the Dallas area. So after law school, I met my wife in college, and then went to law school, and then moved up to the Dallas area, close to where her family is at. And so I decided to practice in Dallas.
Okay. So tell us about your practice. You and I share a couple of commonalities that I like to talk about. Number one, I was always the guy that defended the girls who boyfriends thought it was okay to push them around, or the kid that was bullied. I didn't like bullies, and I was big enough to where I wasn't going to be bullied. So I've kind of always stood up for the person who really couldn't stand up for themselves. And that's a good transition into criminal defense. And I've never been a prosecutor. I have been offered jobs as a prosecutor, and I think it kind of goes against my core fundamental beliefs. I have family members and a lot of the guys I grew up with who need me more than I could ever, justify being a prosecutor.
Yeah, I completely relate to that. My dad was a police officer growing up, so I understand that sort of lifestyle, but I've never been drawn to being a prosecutor. It's always been staying up for the little guy. And like I played hockey growing up, even in West Texas. It was inline. It wasn't ice because we didn't have ice in West Texas, but I was always the defenseman. I was always kind of like that rock there behind the team. It's just who I've always been. I just putting those pieces together over time as I've been realizing why I keep doing what I do. What do we do?
I think sports transition well to what we do as trial lawyers. I played football and did track, and I was a middle linebacker. And you just have to be the guy who will take on whatever's coming at you to play linebacker. So that's true for criminal defense as well.
Yeah, I played linebacker too. In middle school, I didn't play in high school, but middle school I was the weak side linebacker. Because the guy that played strong side linebacker was just a little bit more loose in the head, or a little more nuts in the head than I was.
So tell us about your practice. What's a typical day like in your practice?
So every day is different, but we kind of like looking at it every week. There's 2 or 3 days of docket where you just try and move whatever cases, get discovery, resolve issues, and really work cases. But a typical day is usually right almost to the office if I'm not in court. And I have meetings back to back to review and discovery, and then meeting with experts from time to time as I get ready for trial. But every day is so unique, which is what I love about criminal defense. You can go from murder to DWI to possession to burglary to domestic violence. It is never dull. And so a typical day is, a typical day is
atypical. And a typical day is atypical.
There you go. Yeah.
What would you say is one thing people often misunderstand about what you do?
Yeah, that's a hard question to answer, but I think the biggest misconception for people like other lawyers on network that don't do criminal defense, how do you stand by somebody that's charged with a heinous crime, and are you coming up with ways to create evidence and get them out of the way? No, that's not what's happening. A lot of times it's just really getting to the truth of it, because prosecutors read an offense report like it's gospel, and they think that's the only thing that's ever happened in the world, and they believe it so much. It's really finding out everything else that was out there, and you're kind of playing three-dimensional chess in the sense of what the prosecutors don't know, what the motivations of the witnesses are, and really, I love what we do. It's really getting to the truth, even though, you see a headline and you read an offense report, they just cut right to the chase without really ignoring a lot of important details.
Now, I interviewed a lawyer yesterday. She won a capital murder case. It was a double homicide. And one of the things she said is that we really are here to keep the system honest and balanced. Because you don't want the police and the prosecutors just deciding who's guilty based on who they arrest.
All right. Your client's name's on file. They've already made up their mind,
Yeah, exactly.
Yeah.
I know there are a lot of lawyers in the Dallas metro area. So what sets you apart from those other lawyers?
I'm trying to think of a great answer, but I think there are a lot of lawyers in our area in criminal defense that don't do child sex cases. And there's those I think are the most challenging. I think that narrows down a lot of attorneys just by itself. But I also did family law up until COVID for like 10 years. And that kind of really got me in, especially with domestic violence cases, sexual assault of a child case, anything involving families, kind of really understanding those dynamics of emotions, manipulating children being manipulated or manipulating their parents. And all of those dynamics really play into where you can collaborate with family law attorneys, where we always get referrals from as criminal defense attorneys. And that collaboration, sometimes it can provide better, more comprehensive care for our client or representation for our client, because they're dealing with it day to day, whether it be, child custody issues being brought up because of the criminal allegation, and then how that discovery there outside of what the prosecutor knows and all of that, and the criminal discovery, how it all plays together. And I think that sort of kind of comprehensive sort of representation would collaborate with the divorce attorneys. And it is just that three-dimensional chess kind of analogy. Again, that's where I really kind of thrive based on my prior criminal experience and the type of case it is.
How long have you been practicing total?
15 years. In 2010, I started.
And you've been doing criminal defense the entire time?
Yes, sir. Yeah, criminal defense that whole time, family for the first 10 as well. And I decided to to stop doing that. Yeah. And so the reason why I stopped doing that is because when people would play games with kids, that made me more mad than anything, to where I couldn't leave at the office. Like, I would take it home with me, and it would just be on my mind all the time, and that just grinded my gears.
Yeah, I did family law for the first 3 years of my practice, and as soon as I was able to stop, people think criminal defense is difficult. Doing family law is difficult. But I'm in the school. So right now I actually do LWOP cases, which is life without parole cases in a parish. And which all of my cases are homicides or first degree rapes, which usually involves children. Not always, but most times. And I was in that school of lawyers who did not do sex cases because I have children, and I think I was kind of biased and jaded against those people who were charged with that. And until I represented a grandfather who was falsely accused, his daughter passed away, and he and his wife got custody of the grandchild, and the paternal grandmother made false allegations against the man. And I went to those people's houses. I had dinner with him on Sunday. I hung out with him and the grandkid, and it did something to that man. And I was like, I need to be doing these sort of cases,
Yeah.
So I'll get that.
No, that's a great example. Yeah.
So I gotta know, it's been difficult to get you on here because you try a lot of cases. I have had 6 jury trials this year, and I think the last time we talked for about 30 minutes, and you had tried 7 trials in the summer. So tell me how many trials you've had this year and how you managed to try 7 trials in the summer.
Okay. Since I'm on the backside, I went. It was hard. I'm going to try to never do that again. But this year I've tried 11 jury trials. One of them was a misdemeanor. The other ones were all felonies. Almost each and every one of them was a week long. One was longer than a week. But in the summer, I literally tried one case to a hung jury, went on a Boy Scout trip with my son for a week, came back and tried a fentanyl murder case, and then had a week off, and then tried 3 in a row. I picked a jury while waiting for the punishment verdict for the case that we're here to talk about. And I'd never done that before, where I was waiting. A jury was deliberating on another floor of the courthouse while I'm picking a jury for another case. And how I tried it is, and a lot of the cases, or several of the cases, had a lot of expert issues. And so I forward planned as much as I could. Like, my May and April calendar was full of expert meetings, getting everything in line as quick as I could. And so the prosecutors were very slow on, the litigation packets and the data for their analysis that my experts needed to review. And so that was very frustrating, to where it was very hard to plan, but forward planning as much as possible, having clients on the weekends. I had my 19th wedding anniversary during the summer, and I joked with a jury. It was like, I've been so busy, I don't know if I'm going to make it to my 20th. I hope it's going to be my fault if I don't. It's because every weekend in the summer, I was working. And I had clients over. One of the clients met at my mitigation specialist's house. We met there for hours, and it was just, I was in trial. I had another trial the next week, but I had a client for the week after in my office working and getting ready to testify, just in case they decided to, or probably thought they should. And it was very hard. But having a good team in place too, having an investigator on several of those cases helped me make sure my thoughts are organized about the discovery, and the mitigation specialists to really help, kind of the mental health side of things, and the family care for witness side of things, help manage that as well. Without them, I couldn't have done it. But for planning, expert Zoom meetings, from an expert in California, one case, in Houston another, and a couple local, it was a very good task.
So let's talk about this case that we're here to talk about today. I know we're going to talk about 2, but right now I want to talk about the case where there was a fentanyl overdose resulting in the death of a baby. Can you tell us about that case? Give us an overview of it.
Yes. My Clive Mary was a 22-year-old mother of an 8-month-old child named Ellie, or Elizabeth. and she had a bad drug problem. She, in high school, met with the father of the child, met him up. It was the first real boyfriend she's ever had. And what she didn't know was he had a very bad drug problem. At that point, she only experienced marijuana a handful of times. And this guy had a kind of upbringing and parents that weren't really supervising him very well. But he got into drugs very bad. They started dating, and within a month, she was trying things she's never done, from meth to heroin to all sorts of things. And it was a spiraling situation where she became pregnant. And for the first 8 months of that child's life, they were doing their best to, maintain being parents at their parents' house. But then sadly, one morning, early afternoon, actually, they woke up and their child was non-responsive in the crib, in a weird position, face down, kind of the foam cone, which is foam coming out of the mouth that's, typical with fentanyl overdoses and other drugs. What happened then is they rushed to the hospital, on the way. But the child was already dead. The child was already there, but emotionally they were kind of in denial about, was there a chance to have the child resuscitated? They went to the hospital. Police were already there on an unrelated call, and they were still high and at the hospital. And essentially she gave some statements. And at the same time, the father of the child takes my client's cell phone and starts texting his father saying the police are involved and you got to clean up the house. You got to take this stuff in my pillowcase, destroy evidence, essentially. And so the police are involved. They eventually would get officers to the apartment they all lived in with the paternal grandfather. And then the police are there. They catch the grandfather after he's already, destroyed some evidence, or, packaged up some evidence to throw in the trap. And then they are charged with the death of their child. The charge in Texas that was placed on them was, at first, it was negligent homicide, which is only a state jail felony, which is 6 months to 2 years. But then they amended the charge to injury to a child causing serious bodily injury or death, which is a first-degree felony. And then they interviewed the parents. They were sobering up at the hospital, and they talked about buying fentanyl from somebody in the complex, bringing into the house. And, they gave statements where the dad said he played with the child that morning, which was very important later. My client said she put the child down after a bottle at 2 a.m. in the morning. And then around 2 in the morning, and then the child was discovered around 2 or 3 in the afternoon. But my client didn't know that father had been up playing with the child in the morning. They get to the hospital, and there's some loose statements saying that the child's been dead for 12 hours. And that was just not the case after, autopsy and further toxicology. But at that point, the police were looking at, potentially my client had fentanyl traces that went into the bottle that then transferred to the child via feeding from the night before. And that wasn't the case. It didn't line up. We recovered a bottle. It's not sure if that was the bottle that was being used. There's no fentanyl found in any of the items that my client touched in preparing the bottles or anything like that. And then they did a cell phone extraction, and we found a picture of fentanyl residue on the father's thumbnail. And so, we were trying to show that the father was the one that had last contact with the child that had any sort of fentanyl nearby. And so it really was, was she responsible under the law parties or an accessory, as the jurisdictions call it. And that's the case in a nutshell.
Got it. So when they upgraded the charge to a first-degree felony, what was the penalty range at that point?
5 to life with a chance of probation. So 5 years to 99 years of life in prison, or up to 10 years probation if the jury recommended.
I want to know about the client when she came to you or when you first met with her. How did she find you, and how did that meeting go?
So I was court appointed. I do indigent work and retained work. In my county, we don't have a public defender's office. We do kind of a indigent court appointed wheel, kind of like not like a true managed counsel office, but something similar, essentially private attorney's counsel list. So I was appointed to her. I wasn't her first attorney. Once they upgraded the charge, that attorney bowed out. And she wasn't on that wheel. That was a higher level offense. And so I was her attorney. She had bonded out by the time or was in the process of bonding out when I was her court-appointed attorney. When I first met her, I could tell she was really down and depressed about the death of her child. She had already given 2 interviews with the detective of the case, so she really poured her heart out about everything. She was upfront and honest about her struggles up before and what was going through her mind after the fact, and really processing the death of the child. And she actually had a moment where she bonded with a detective who had a child lost in his own life, and it wasn't just a ploy. They had a genuine late moment where they were talking about stuff and they were wishing each other well. It was kind of refreshing to see. But when I met her, she was already in that process of really working, what you and I call mitigation, working on herself and rehabilitation and all of those things.
Okay. When you first met with her and got your hands on the discovery, which is the evidence in the case, what were some of your initial concerns?
Whenever you have a death of a child, as defense lawyers, we're always worried that, a jury is not going to care and to say you're responsible as a parent and you're going to be found guilty, just whatever defenses are. And so that was the main concern. Obviously, and fentanyl is such a huge problem. It was that, it's like the drug of choice for the last several years. And just so the strong emotions with fentanyl, just those 2 things alone was a huge concern, like how we were going to deal with that. We were worried that, the jury's going to be hanging, decades on our client because of just those 2 facts alone. And so it was really processing from her point of view and tracing how this child died, because the scientific evidence did not match up what the initial 12-hour death window was. And, that they believed it had to be from the feeding, because that's what you always typically hear, that formula and fentanyl get mixed together and it goes through an oral cavity, i.e. the mouth, and that's how the child dies. And nothing was matching up. And so we had to look at exactly what, how did this fentanyl get in this child? Because of how the room was laid out, the child was in the crib, there was no fentanyl found in the crib. And then the extenuating circumstance of grandfather cleaning up the room and father playing with the child when our client had no idea, kind of created this big mystery to where if the scene was cleaned up, like, could a jury just say, okay, well, of course the child had to die this way and mom was, one of the potential last people, and they were going to jump to that conclusion. And so there was a lot of circumstances of that tampering with scene was that a good thing or a bad thing for us, even though my client was overcharged with it, because literally on the body camera, you see the father take the phone from my client and lean over to the side. It's texting in front of the officer, clean it up. The cops are here to destroy stuff. Like, it was crazy.
So that leads me to my next question. I want to know, what was your defense theory and how did you go about building that theory?
So when it comes to the theory in this case, after we found the picture, it was literally a picture on a cell phone. It was all the info was my client's cell phone, but it was a man's hand, and he was holding a foil sheet where, if your viewers don't know, what they do is they put a fake Percocet pill on a foil. They have a lighter underneath that basically slowly melts it, and then they inhale the smoke. And sometimes the residue, as the pill is melting, will come in either globs or chunks or just kind of slime. And there was residue that sat on the thumbnail of the father. And so the baby is 8 months old, teething. And so our theory was that when he says at the hospital, I played with the child this morning, and that's the last time he saw her, because my client woke up at 2 p.m. I knew that he wasn't at work, so he kind of had the morning shift, but that was all she knew. I had to assume that it must have been him. And there was a bunch of statements about, him saying, hey, you should Narcan her. And mom was like, why the hell would I need to Narcan her? Because she was like, I never had fentanyl near with the bottles. I never had fentanyl when the bottles were being made. I always washed my hands. I didn't wash his hands twice because it was always just out on Xanax and fentanyl and everything. Though when it came to the defenses, it was really getting the thumbnail picture to highlight or to line up with the toxicology, the autopsy report, our review, or our independent medical examiner expert in the timeline with toxicology results to show that the child actually processed or metabolized some of that fentanyl, with some of the fentanyl and the antibodies, not the antibodies, but the components were found in her urine. So she had processed it. It wasn't an instantaneous death. And so we had to line up all the scientific data, the statements of the parties and everything to recreate that morning to show that our client was not the one that was actually, the analogy we used was like bringing drugs in the home is like loading the gun, but who pulled the trigger? And our argument was that the dad pulled the trigger. And so our defense was to see if we need that to either a not guilty or a lesser charge. And that's to show a different mens rea of reckless versus intentional or knowingly, because a charger by intentionally or knowingly by omission, exposing the child to fentanyl, which caused her death. And so it was an omission, but the state didn't have to prove exactly what the omission was, which created more difficulty for her. We had to show as much clarity as possible that dad was the one that had that final contact. And so we really had an uphill battle on our hands on the guilt and innocence. But that was our defense on guilt and innocence.
Gotcha. Did you have an investigator on this case?
I did. Yes, I did. I had a private investigator. I use this firm here locally in North Texas. They're Blackfish Intelligence, and they are a great investigative firm. I use them for a lot of my cases, regardless of what the charge is. And they do a lot of cases in North Texas and other places in the state of Texas. But Blackfish Intelligence is a great firm that has their own digital forensics lab and investigators that do only digital forensics. That played a significant part of it. They found the picture of the fentanyl on the father's hand from 7:30 in the morning, right before he played with the child. So they helped me out tremendously, both on the witnesses side and the digital forensics side.
Okay, so the investigator you use, is it routinely something they do? Like because these cell phone dumps can be massive. So
yeah,
you'll use the investigator to review the entirety of the cell phone dump?
Yes, yeah, we did. Because you're right, these dumps are like gigabytes upon gigabytes upon gigabytes. And like, if you want to find somebody's search history from the incognito tab, 2 months ago, and that they don't know that their wife doesn't know they're searching them in private, you'd find anything on these phones. But we were able to, since we only had a 24-hour period, we were really looking at maybe 36 hours. If you want to just like really flush out the whole thing to show they were exactly wrong about the 12-hour time frame on death, we broke down her phone and another cell phone of the grandfather. Here's the funny thing. When the police went to the apartment to process the apartment, there was a bag of evidence, including the father's cell phone, the baby's dad's cell phone. And they left that bag, and the family, the father's family and the grandfather found that bag and threw that away. And so that evidence was lost. And so evidence of drug transactions, whatever that was on father's phone was not available to either party. And so that kind of created this big question mark too. Obviously the spoliation issue, that kind of went into our favor a little bit, but there was just a lot of little gaps in the evidence collection that were extra challenging. But when it comes to the cell phone, we were able to look at the exact location data, the text messages that were sent. My girl's cell phone would be used by the father of the child because he was basically talked to the dealer and the guys of fur because the dealer didn't want to deal with him because it's a jerk. And so she would make the contact. A lot of men, as you know, sometimes would use women as the intermediary to pick up drugs so that they can't be pinched if there's ever any sort of investigation or sting or whatever. And so she was kind of the runner. Now, she was equally responsible in using and all of that, but he would constantly use her phone. And so it looked like Haley, who my client goes by. And so her phone was kind of a mix of dad's messages and her messages. And you could kind of tell between the two. We had to show that to the jury. And the body camera helped because it showed the exact messages about deleting evidence or destroying evidence at the scene with our body. Yeah, that in real time. It was, yeah.
That's beautiful.
Yeah.
But that takes a lot of work and attention to detail and case prep that lawyers should be doing anyway. So let's get to the trial. We know what your theory is, and we start dealing with our theory of defense in jury selection. So tell us a little bit about jury selection.
Jury selection in this case, I thought was very interesting. I talked about a lot of things personal with the jury. I like to talk about a lot of things in my life that are personal, and the more authentic you are in jury selection, you can connect with jurors, and they will follow that emotion with you all the way through trial. They can tell if you're being fake, but with the death of a child, I talked about something that was very private to me, and I'll just set it up real quick. When my wife and I got married, it was the first year we were in law school, and We said we wait 5 years to become pregnant. And then that first year, we went to Fiesta Supermarket, there was a sale of 3 bottles of wine for $20, and that 5-year window went right out the window. We became pregnant right away. It's so, that was kind of the joke I set up. And I joked about that with the prosecutors and stuff like that. And I even told that that's a joke that I've shared with everybody in the court, not everybody in the courthouse, but a lot of people, it just comes up with. And I said the part of the story I left out is that first child that was conceived, we had a stillbirth. At 8 months, the last check-in for the last routine check-in appointment, there was no heartbeat. Me and my wife went through this very traumatic experience to where our son, Kale, was never born. He was stillborn at full term, and she had to deliver him just like a regular childbirth. And that really screwed with me and my wife's head. It still does. More so my wife, because she was the one that had to start with the passage, the delivering. But we talked about that because the emotional guilt we felt, even though we didn't do anything, which was kind of an analogous to the omission in the indictment, is we had to separate. You get the jurors to acknowledge that separating emotional parental guilt, that sort of emotional guilt, versus what the legal guilt is. And that way they'd rush to the emotional parental guilt and just find guilty based on that alone. In that case, we talk about the death of a child, fentanyl. It was very easy for any juror to say, you know what, screw it. I don't care. Guilty, whatever, and just jump to that conclusion. And we got them to really buy into, like, we really have to break down to what legal guilt is and really get them to conceptualize that the emotion and all that other stuff, like all the jury charges saying no sympathy, it's just analyze the facts. We had to really kind of get that honed in. And that was kind of how I set the table for jury selection. And then from there, talked about what an omission is and, does an 8-month-old require a larger omission in order to cause injury, for example, because they're not mobile? And so, obviously you can't talk about the facts, but you can pose hypotheticals, like, does a bigger omission require to get an infant in trouble? Versus it's easier for a 12-year-old to have a mishap because they're more mobile, they can reach things and all that sort of stuff. And so we come to really analyze, does the age of the child matter as it relates to the omission? And it has to be more intentional for a child to actually get exposed to drugs. And so if we can show lack of intention, it was maybe reckless. We started working them down to where they kind of conceptualize, okay, if I put myself in that situation, and I use the analogy of bleach, bleach could be something that could poison a child. And so what steps to take, does it require more of an intentional omission? And if you don't do that, is it an accident? What is the substance shouldn't really matter. You can put them personally in that sort of position, hypothetically, where they can look at how their children may have done stuff where, they drink a bottle of whatever and then their child turned out fine, but the anxiety and concern, all that is relatable. And so that was how jury selection kind of started unfolding.
Always cover the issues in the case, even though we can't get into the facts. We have to pick a jury based on those individuals who may be receptive to dealing with the issues as well as our defense, our theory, right?
100%. 100%.
So then we get, after jury selection is opening statement. The prosecution goes first. Walk us through their opening statement and then tell us about your opening statement.
Yeah. So the state's opening statement was strong. This parent is responsible for the child. The child died. Fentanyl, she brought it in the house. It doesn't matter. They didn't say it doesn't matter how, but basically kind of unspokenly said she is responsible. It does not matter. That's the omission, is that she brought drugs in the house, and that is all that is needed to show. And their opening was pretty short and effective. Sometimes that's better, even for us defense attorneys, sometimes getting in, hitting them hard, riding them out with what matters and then moving on. But there it was very straightforward. So my opening, I opened up with the line of, you're not going to like my client. You're not going to like what you see. You're not going to like anything that you hear the day at the hospital. You're not. You're not going to like. But that doesn't mean that the state was prove their case. And then I go from there. And I talk about how.
You're going to use that. I'm going to steal that because I can go through a list of clients that's applicable to.
Yeah, right.
But go
exactly. And so I made that promise. You are that first reaction and what you see, you're not gonna like, but you have to keep that open mind and really break it down. And then I talk about the jump into inclusion and the 12 hours and here's what you're going to hear. That none of that makes sense. And what's really underplay is this and this. And then I talked about a reckless mens rea, which is a degree lower, which would lower the range of punishment from 5 to life to 2 to 20. And so just limiting that exposure, increased the chances that we were hoping for probation if she was not acquitted, which we really didn't think she was not going to be acquitted. We always thought it was going to be maybe a lesser charge, and we were aiming for probation. But then laying that out and opening, talking about you're not going to like it, and then you really need to break it down and look at what's consistent through her statements, because she's interviewed by a couple of control officers and then the detective twice at the hospital, and then the detective again after she's arrested, and putting all that together to see in the mind of someone that's coming down from fentanyl, being smoked and being high at the hospital, if you can tell as she sobers up, things that are consistent will line up with what her story is, which shows that it wasn't intentional or knowing omission. At worst, it was reckless. And so talking about them to really analyze what's said and ignore not liking the person that's high at the hospital with their dead baby in the other room, and her sobering up and getting them to really appreciate that, I think really helped.
I'm glad you said that, because it brings me to a point that I think a lot of, well, primarily young lawyers and the public in general might expect or not understand is they expect us to always go into court in a jury trial and argue for a not guilty verdict. But when a person is charged with a crime, we call it responsive verdicts here. So whatever, if they're charged with second-degree murder, there's lesser and included offenses, manslaughter, negligent homicide, then not guilty.
Right.
So in this case, it seems like you were more focused on a lesser offense because you didn't anticipate a straight up not guilty. So strategically, why did you do that in this case, and why is that something as a lawyer you sometimes feel is appropriate to do?
I'll answer the latter part first. I think you maintain your credibility with the jury from the beginning of opening through the end, because studies show that a vast majority, the 80% of jurors, will make up their mind at the end of opening statements. And then really psychologically, they're confirming their initial suspicions of the case or their view of it. And so if your client is responsible on some level, and sometimes it can be a different charge the prosecutors opted not to go on. Like, for example, this week I tried a domestic violence case that was aggravated assault. My guy damaged her car, but he didn't do it threatening even a bodily injury, because they charged him by threat using a deadly weapon. And so he was found not guilty because we said from the beginning, he is guilty of criminal mischief, which in Texas is the intentional damage of somebody's property without their consent, based on property value, et cetera, et cetera. That way they know we're not just like going, nitty, nitty, boo, boo, you can't prove us, you can't touch us, We're guilty. We're responsible. It's just not best one. It's the same thing with lesser included offenses, as we call it here in Texas. It's you maintain your credibility from the beginning to say, look, we are responsible for loading that gun, but we weren't the one to pull the trigger. We use that gun analogy a lot to say, yeah, we helped load that gun. We weren't the only one that loaded that gun. And we're going to show you who pulled the trigger, and it wasn't us. And so that wasn't the intentional or knowing omission. That was the stuff on the thumb. That was the mechanism. Our client didn't put it on there. That was his independent action. We'll explore our theory well. So look, the fentanyl would not have gotten there without mom being a part of it. And so, ladies and gentlemen, we're going to ask that you find her guilty of reckless, which is a lower offense. We said that from the very beginning. We never said, I even uttered the phrase, you're never going to hear the words that would come out of my mouth, not guilty. You're not going to hear it. And what you are going to hear is that all the evidence shows that she's reckless, not intentional. And I think the jury at that point really kind of it almost took a little bit of anxiety out of their decision to say, okay, it's identifying the right charge. I can get motivated for this person, this human being that's on trial, if I know she's not trying to just dodge and skate out on responsibility, where everybody hates when those, especially rich, connected, clients get off on a little technicality and things disappear, or that Epstein ever comes to light, They hate that stuff. And they feel better about making a better, more accurate decision than some people that will say, you probably talk to juries afterwards. They don't feel good about voting not guilty sometimes. They feel like this was not a good situation. I want to fix this. Like, everybody wants to fix the situation and make sure it doesn't happen again. On a societal level, And so sometimes just going straight to it and saying he or she is guilty of a lesser charge, that maintains your credibility throughout, and you can really hammer those distinctions.
I had a trial. The guy was charged with armed robbery, and he was an off-duty police officer. And there was a drug deal going down in his neighborhood. And he's jogging, and he jogs up on a drug transaction. And he takes the drugs, he throws them on the ground, he fires his gun in the air and tells the drug dealer, get the fuck out of his neighborhood. But there was a internal conflict in that police department. So they charged him with armed robbery. And I argued to the jury. I was like, he didn't keep the drugs. He didn't keep the money. Should he have been charged with illegal discharge of a firearm within city limits? Absolutely. He should have. But armed robbery, that's not what this is. And they found him not guilty.
Good. That's a crazy fact pattern. But yeah, once you said the difference of politics and the office, that made a lot more sense.
Yeah. You don't typically have police officers getting charged, but they wanted him out of there. And so he was already on eggshells. So let's dive into the state's case. They called witnesses. I'm not sure how many they called, but if we could highlight who you deemed were their important witnesses and how you dealt with those witnesses on cross.
They called about 5 witnesses. They called the responding officer to talk about the behavior of the parents at the hospital. They called one of the nurses, who was the one that just kind of out of nowhere said 12 hours is what they probably think the child had been dead for. As a nurse, she's not qualified to make that opinion, but that was what really started everything. We wanted that to be what was the front of mind for the detective, who was our next witness. When he was interviewing them, he was really focused on that 12-hour window, even though how the child presented in the hospital wouldn't line up with the death for that long. I mean, the child would be stiff or rigor mortis, very hard. There was a little bit already onset, but not enough to be 12 hours. Like at that point, the body starts breaking down. That sort of bluish skin, the blood bleeding, and the child was white. So that's a little bit more present in a white deceased child or a white person, where that blood is really pulling under the skin. That wasn't there. There was a little bit, but not anything that would line up to 12 hours. And so we really hammered on this investigation, started on a really bad assumption about when this child potentially died, which reflected on or affected how you grilled this mom. And dad kind of skated on it a little bit, but he still made admissions to playing with the child to certain time. He said it several times. And so we really crossed on, you focused on a bad time frame. This guy is looking at, the father is the one that's admitting to you that he's playing with the child. And you jumped to a conclusion and really crossed him on that to really lay that groundwork of you are looking at the child being exposed to fentanyl and completely, you're off by like 5, 6, 7 hours. And so we really crossed on that. And then the next couple witnesses were the medical examiner that did the autopsy on the baby or toddler and really got him to buy into that sort of timeline. By the time they came to trial, the cross years were really much more in line with the time frame being a lot sooner than the police were. And so they presented their case that way, which kind of undercut the credibility of the detective on his investigation, not him as a person, but like you're operating off of left field, but really at trial, they're operating closer to where we want it to be. And so that kind of caused some tension with his statements that he made versus what they're trying to polish up and, woodshed at trial. And so we kind of showed that, he's now singing this tune, but back then he was singing this tune. And so that undermines your credibility about which party is actually more responsible. And their toxicology expert, we come to kind of hone in on that as well. So we kind of co-opted their experts to make them more in line with our theory and timeline. And then we had a photograph of the residue thumb, and we presented that to the detective who never saw it. Like he never looked at the digital forensic. He packaged it up and sent it to you.
He just dumped it and handed it off, and probably hoped you guys wouldn't have looked at it either.
Yeah, I was like, oh, what's this? Oh, we really can't tell that. Oh, so you're saying now in your training experience and knowing all these drugs that you talked about direct, you're not saying that the foil and the blue stuff on the stomach is not fentanyl? Well, it possibly is. Oh, okay. So you can't rule it out. No, I can't. No, it's just, that normal, they're protecting themselves. They don't want to look bad, but it is there. Like a juror's eyes don't lie to them as fentanyl, and they timestamp the exact moment, location, exactly who it was. It was kind of hitting them with things that they didn't really fully appreciate because they're operating on a wrong time frame and using that to really undermine their credibility. And so that was the state's case, and those couple experts and couple witnesses.
Okay. And you've kind of covered how you dealt with them in Cross, how essentially the timeline that didn't add up to your client being responsible because she had touched the baby last at 2 a.m.
When I asked the jury about consistency, she was always consistent about when she put the child down, never really woke up in the morning. There was a time she stirred and saw that he was there. And so she knew that he had a morning shift because sometimes he would work, sometimes he wouldn't. And so she kept sleeping. And then she woke up, discovered the baby, and then the father had smoked again and was high, and she had to shake him awake. And so that helped really show that he was really up and down, with the child, then smoking, then down, sort of thing. And so that's how we handled their case.
Did you call any witnesses?
I did. Called my own experts. So I called my own medical examiner that really honed in on the time frame. His name is Dr. Evan Natchez with NAAG Forensics in California. He is easily one of the top 5 expert witnesses I've ever called on the stand. He was very good, very thorough. He re-reviewed everything from the autopsy, histologic slides, and other things. I learned so much from him working this case, and that I can use for future autopsies and things like that and other cases that come down the pike. He really honed in on the time frame being a lot shorter than the 12 hours. And so his testimony then lined up with the next expert, who was Dr. Adam Cannon, Canion. He's an ER doctor who also participated on infant death review panels out in Tyler, Texas, and East Texas, NMP. Really talked about how parents in the ER, because they really honed in on in the state's case, that the parents were out of it, acting weird, and all of this would show that they said being deceptive and lying about what happened and all this other stuff. But really what we talked about is that in his experience, doesn't matter if they're rich, educated, poor, broke, high, not high, people respond to a child's death completely randomly. And that affected how they presented, to where those initial assessments of the parents early on were really not reliable. They're going through a traumatic response and this desperation. Also, the hospital was told by the police that you can't tell these parents their child is dead because they want to hopefully get them to keep talking to them. If they're hopeful, then they'll talk to the police to talk about what's going on because they're so hopeful that the child is going to be resuscitated. And so law enforcement actually told medical personnel to not tell them their child had actually died a couple hours before while they're interviewing both these parents.
Is that proper?
Jury didn't like it. I don't know if it's proper or not. I don't think it is, but the jury sure as hell didn't like that either.
I don't like it.
Yeah, I don't like it at all. And they tried to minimize that they really did that, even though it's reported on their body cameras. And so I get to play that clip. It's like, okay, what did you be here when you said don't tell the parents? They tried to lie about it. I'm like, come on. All right. It is recorded. So yeah, and then so we talked about how parents in the ER present differently. But then also the ER doctor talked about the time frame once a child's exposed, because they tried to insinuate that with that 12-hour window or 6-hour window that they could have done something to keep the child from dying. But so this ER doctor came in and really talked about once a child's exposed and the signs start showing, unless you're there awake, the child could die in your sleep. And so we kind of talked about where my client was asleep. That wasn't in and of itself an omission and he also talked about how the way the child would die would basically be they lose control of their respiratory system, the nerves in their head and neck. It kind of paralyzes them. And so they're kind of awake and not able to breathe. They're up there for also not able to scream or yell or cry. So if you're asleep and your child's exposed, basically the child would die silently in your sleep. And there's nothing you can do to respond to that, because they try to say that they also failed to timely seek medical care, which is a manner of means to be alleged. But that was our answer to strongly say that they didn't fail because they didn't have an opportunity.
Right.
And so then our third expert was a toxicologist that really honed in on the time from contacts based on the metabolism and the toxicology report from the autopsy to show that the child probably died, processed the drugs for a period of time, and then succumbed. And that all lined up very close based on what our medical examiner said, their medical examiner said, plus the toxicology to show that thumbnail picture was right in the splash zone of when this child got exposed and died. it really honed in on our theory of the case and our timeline. And I think we proved the case more than the state of Texas did about how this child actually died. Not that fentanyl was brought in the home and all that. I think we actually went above and beyond to really show this is exactly what happened that day, and it lines up with this picture. And so you have a culprit on this stand. Another witness I called the officer who had the body camera showing that the picture, the text message was in the father's hand that was destroy stuff at the scene. One of the things the prosecutor did that really rubbed me the wrong way is she had all these text messages, and the dad and the grandfather were charged with tampering with evidence. And so she knew all this and still said when she went through the text messages that were sent by dad on body camera and said it was in fact this defendant that sent them. Like she was essentially lying intentionally to the jury saying, and she, I guess, was just hopeful that I wouldn't call that officer to come show that that was complete bullshit. And that was the one thing that really pissed me off about how the state handled the case. And so I subpoenaed that officer overnight because I said, hey, will you route him here? And they're like, no, we won't plan on calling him. You have to subpoena him. And of course, what they've done in the past is if we need an officer on their witness list, they'll say, okay, we'll make him available for you. That's the kind of the agreement they had. But since I had him on this, they said, you have to subpoena him. We're not doing that. And I was like, all right, screw that. Screw you. You got a subpoena that afternoon in the middle of trial. My private investigator served on while he's at work doing the night shift. I called him on his cell phone, and he was very cool about it. I said, I'm coming in. All you do is come in, so is your body camera, and I'm not asking you any of the questions. And so he was very professional, came in, I played it. The prosecutor pissed and moaned and tried to see if I would stipulate and not show the evidence to underline. I was like, oh, you?
Yeah, you had to go after her credibility at that point.
Yeah.
And
so that kind of fed the whole narrative of the police, how they handle things at the hospital and how it's being tried. And I think as defense attorneys, we had to be very cognizant of how we do everything. It doesn't matter of how small the detail is. We have to maintain that credibility holistically throughout the case.
We don't get a pass. We don't get a pass like the prosecutors do.
Exactly. We don't get a pass. And then, oddly enough, I called the father, and he did not take his Fifth Amendment right to not testify. Blew my mind to the point where I had written out a framework of a cross, but I actually didn't write a cross. I was like, oh, this idiot's not going to testify.
That's right.
So he waived his Fifth Amendment the night before. It was the last morning of Guilt and Innocence. He took the stand. And so I called him, and I asked him, what do you think out of that day? Just an open-ended question, which with a hostile witness, you almost never ask questions you don't know the answer to. But we had all this social media where he's bragging, his lawyer says he's going to walk and all this other crap. And he didn't know we had the picture of the fentanyl on the stump. And so this guy takes the stand and says, she poisoned her intentionally. Like she intentionally killed my kid. Not by omission, none of this. So he's operating often beyond left field, left field and over there. He is like out to get her. And so I just slowly built up this cross. I built in a little bit of, mitigation. I did this thing. It's a little cheesy, but it worked really well. I asked for my client's sobriety pin, and I said, give it to me, like the morning before I started. So I put her 2-year sobriety pin in my pocket, and because my client had to wait for 2 years for trial. And so I walked up and asked if he knew what it was. And he said, oh, is that a sobriety pin? I was like, yeah. And I talked about how it was mine and, all this stuff. He goes, oh, that's really cool. And I looked at the jury. He goes, I have to be honest with you. I lied. This is my client's sobriety pin. Do you have one of these? And so.
Oh, that's not cheesy. That's pretty cool. I like it.
Yeah, then I walked back to the table. I played right in front of my client, put my arm on her shoulder. And then he, like 25 minutes into it, he cried uncle, and I took the Fifth Amendment. Because I talked about this section is on body camera, this is this, and this is this. And his case was still pending. Like his case was not resolved. They didn't have a plea agreement. They just opted to try my client first separately. And so he took the stand, and ultimately his testimony was struck for record purposes, but that sits in the jury's mind forever.
Yeah, you can't delete it from their brain.
Exactly. And so that helped out a lot for closing and then punishment. But yeah, so that was our case. My client opted not to testify, but because we had her timeline clear as day all the way out. And so there was no need for her to testify.
That brings me to a couple of points. Your client was charged with the murder, but the dad was not.
No, he was. I'm sorry, he was as well. I'm sorry, I didn't say all the charges. They both got charged with the death of the child. He got charged with tampering.
With evidence, additional. Gotcha. He had additional charges in addition.
Yes.
All right. So the other thing, it sounds like you did what I typically do. When I have clients who have given statements, I typically encourage them not to testify because it's like, look, they have your statement, they are going to play your statement. The jury is going to hear from you anyway. Is that something you and your client discussed?
Yes, 100%. So they played. I didn't object to any sort of hearsay as it relates to her interview at the hospital. We argued suppression because some of the things in the hospital introduced is not what we liked. We preferred her interview at the jail after she was arrested. The court opted to not suppress her testimony, and we had a hearing obviously before trial started on that. And he made some statements of how there was the encounter was voluntary and all these other things, and he kind of exaggerate some of the truth of the things. And so when I started crossing him during the trial itself and bringing up these voluntariness issues and kind of really messing with his credibility because withholding the child had died and all the other stuff kind of built in, because they didn't Brandeis her at the hospital till after they told her the child was died, and they're like, well, crap, maybe we need to read her Miranda rights now, because once you manifest probable cause to the suspect and you don't Mirandize them, then anything after that is, so potentially suppressible, and so they said one thing, because he kept arguing, we didn't have probable cause until, basically when I Mirandized her, essentially to cover himself for not having Mirandized her a lot sooner. I try to keep the interviewers a little bit more rough, but once they were coming in, we just had to adopt it and to deal with it. But yes, but once all that statements were out, and then on cross with the detective, I really went into all the things that were really good about her jail interview. And he really had to kind of buy into that because that was a moment they actually bonded, which was actually a very sweet moment. There was a moment where we approached the bench after I had him on cross for a couple hours. He'd look at my client, he kind of shrugged his shoulders and asked my client, what was that about? And I think my client said, I think what he was saying is, hey, tell your lawyer back off, because we kind of connected. Like, it was kind of funny. Like, but I was like, no, you're on for my client and close her off, the truth is going to come out. And so I really highlighted how it was completely different afterwards, and that was kind of setting the stage for punishment that my client, poured out who the dealer was. And basically she was raw. Like nothing was holding her back. She was open and honest about everything. But she also did contradict the important details of her first interview. And so that she was very credible all the way through the investigation about her problem. She wouldn't do the right thing. That she was clear about, like, I wasn't the one that last had it, but I'm responsible as a mom for bringing stuff in. And it really helped her credibility, even though she didn't testify.
So take me through closing. Most places, most states, and I believe that's true in Texas as well. The state goes first, then you close, and then they get a rebuttal close. So you get sandwiched in the middle.
Yeah. We still get the same amount of time, but they get split theirs up. Exactly.
That's true here as well.
Yeah. And so, but some judges don't do time limits. So that's not a hard rule. But this judge did do time limits to where we both got, I think it was 30 minutes or maybe 35. And they split theirs up how they wanted to. They did their whole hard line. She's guilty of the first degree, yada, yada, and all that. I mean, very typical, kind of downplayed the whole, everything that we brought up. There wasn't anything unique about their closing in the sense of if they did the same sort of thing all the way through. But with my closing, I really echoed again, like my client's guilty of the lesser, that's exactly what, she's guilty of. That's what we showed. Here's how their investigation was handled, and here's how the things were exaggerated, and they took advantage of this, and how does that affect what she says on the video? Being withheld. If you're sitting there thinking your child, there's a chance that she's alive, and she's asked several times for hours that your child, is she okay? Is she okay? And then they're just saying it's okay. We need to know this. We need to know these details, and they're kind of like wanting to help out, being self-defensive, but emotionally erect. And so we really kind of said the law enforcement really to manage these pairings, even though you may not like a single thing they did because they brought fentanyl in this house and the child died. That helps minimize, or not minimize, mitigate some of the venom that they felt towards my client. And so I kind of harped on that a little bit to really push that mens rea down to from intentional, knowingly, or reckless. And I just honed in and said, who do you think proved this case? Who do you think proved what happened on that morning that the child died? I think we did. And we didn't have to prove anything, and I really honed in that we kind of took that mantle that they always, wanted to run with, of proof beyond a reasonable doubt. I said, what do you think provided the actual timeline of what happened? And what did you to ignore this, do you think you would have ever seen a picture of fentanyl on the thumb unless we brought it to you? What does that tell you? You know, they're jumping to that emotional guilt. I guess reiterated that emotional guilt of this person's responsible, hang him high, da-da-da-da-da. That's not how we do things. You have to break it down and follow the evidence and follow what actually happened. And so I kind of weaved in the more dire plus the opening into that was.
Beautiful, beautiful. What was the verdict?
We were actually unsuccessful on getting the lesser. So she was found guilty of the intentional or knowing. And that's the little twist here. She was still found guilty of the higher degree felony. And that was on Friday afternoon. And so my client stayed in jail. She was on bond up to this point. She stayed in jail the weekend and she was terrified. The final offer in the case was 10 years TDC, which I can't say is not a good offer for a death of a child, 10 years. And then that took a while to get them down from 25 to all the way down to 10 for months up to trial. And my client really racked her brain about whether or not she wanted to take that offer. And here's one thing that's happened up to this point that we hadn't mentioned. While she's on bond, she finds a new boyfriend and they accidentally conceive another child. And so she is pregnant and delivers a child. And on Wednesday of trial, her new baby is the exact age of the child that died.
Oh, right.
And that was, so she was like, I've done all this work. I've done all this mitigation. I've done all this rehab. And she did all of these things to where she said, if there's a chance of probation, I have to take it. I'm not going to take the 10 years. And she was so brave to do it. And, yeah.
Who imposes the sentence? Is it the jury or?
So in Texas, we're one of 4 states, and I only know that because the judge in my last trial said that, and I hadn't done the research. But in Texas, we're one of 4 states where the defendant before trial gets to select if the jury assess punishment or the judge. And so
I don't know that option here because, oh my God.
Yeah, no, it is definitely the unique thing. It's a hard decision to make, but with this case, we weren't sure what the judge is going to do. Like, you know, the judge we had, Judge Edgeworth, that's in IT, is a great judge. She's very smart. She has a civil background, but with anything involving a child, you know, as a defense attorney, I'm always worried, you know, and I don't think judges strictly, you know, think about how their verdict will look in the paper or anything like that. But at the same time, I'm a little cynical. I can't rule that out. I don't think Judge Edgeworth's like that, but I said, look, with the death of a child, I don't want the judge to be in a position where she's soft on crime, but she's not. Trust me, she's not self-defense. You know, I've had some punishments come from birth that were justly very high. But I told my clients that I think it's better to work to choose a jury. And we chose a jury. And so the jury, we'd go into a punishment case, which is basically just like guilt innocence. The state calls their witnesses and we call our witnesses. And then we do, sometimes we do opening, sometimes we waive it. And then if the state waives it, then I don't get to give one. But then we get a closing argument on punishment. And so, you know, that was the next phase of trial.
And your client gets sentenced to?
She gets probation. She got probation from a jury. And, I couldn't have been happier. I think the dad testifying really helped. And I argued in punishment, like, when you have a traumatic event like this, you can respond in different ways. You can respond how he did, or you respond how my client did. And in guilt and innocence, we had all sorts of people come testify for her. We had 15 people that wanted to testify, but it was a lot of duplicative, and I just couldn't, you know, we just can't call witnesses to just be a dead horse. But we called 5 witnesses, and then my client testified in guilt and innocence about everything that she's gone through. And we had a treatment provider that was very spiritual. We had a business savvy person that runs halfway houses that she worked for a period of time and was supervising her child on bond. And we had a family member come in and talk about, you know, her being adopted and the drug struggles that her biological parents have. And, you know, sometimes that will bleed into somebody else's life where they're more susceptible to chemical dependency and chemical issues. And we talked about the first boyfriend and really shaping her down this road, and my client did so much work. My client was very sweet. She would call me and say, hey, I've done this, this, and this. Is there anything else I can do? And I told her a couple of times, you've already done more things I knew that existed, like there's more strict treatments and stuff like that. I'm like, I have no idea what else you can do. You've done more than I knew existed. And I was blessed to have a very good, motivated client. And she got probation from a jury. She's out now. She has no supervised visits to her new child, and she's thriving. And it's an amazing result that we were really worried, because once the jury found her guilty of the first range of punishment and the first degree and the 5 to life, we were really worried that they weren't going to consider probation. But I think we really turned it around, because in my closing for punishment, I said, look, like I told you in punishment, or guilt innocence, I'll be in closing, you're not going to like my client, but I hope you have a completely different view of my client now, as you see the end of the story, in that you see somebody that's taken advantage of the opportunity of learning from the death of a child and is now thriving, where there's a new child. They learn that punishment for the first time. We were really worried what that was going to be like. She didn't care. She brought another child in this world. How dare she? All of that. Though we made such an impact with the jury that I provided a thumb drive of a lot of pictures of the baby, but I didn't publish it. I said, look, these are here for you to see that this child's thriving, he was healthy. But based on all the witnesses that we provided, I think you should already know that. And that these people that aren't family, that aren't related to her, have come speak for her. And it all worked out. Sorry.
No, I was going to ask you how did you feel about the result of this case, but I don't have to ask. Like, it's showing all over your face, and I think it's beautiful. Like, people think those of us who do this job don't care. It's just a job. That is so not true for majority of the people that do criminal defense. I mean, we take this stuff home with us. We go to the clients' houses. Some of the people I've represented are genuine friends to this day. And a lot of them who I wouldn't say are friends, we still keep in touch, and I check on them and they check on me. I wish the result you got in this case, I wish it was possible in Louisiana, because here, the fact is, in your case, my clients, and I have clients right now charged with second-degree murder. And in Louisiana, the penalty for second-degree murder is life without parole. The sentence is handed down by the judge. There is no discretion. So if the client experiences a traumatic loss like this and goes to rehab and gets clean and gets their life on the right track, and they go to trial 3, 4, 5 years later, none of that stuff matters if they're found guilty. And that does not serve that person well, nor does it even serve the public, because we have somebody who's changed their life, who can actually be an inspiration to others, but we take that person in Louisiana and we send them to prison for the rest of their life. And that is absurd, and I think it's cruel, and I don't know who it helps.
I hear you, and I am lucky to practice in a state that allows juries to hand it down. I even talk about in closing, it's beautiful and terrifying that the way that we have juries potentially hand down punishment, terrifying from our perspective, because there's no guidelines. It's the exact opposite. Like with 5 to life, there is no guidelines to say in this case it should be this, in this case it should be this. It is really what the jury thinks is right, which in the same way is extremely beautiful, that the human element can really come out. And I know that leaves potential for people to get swayed and people to put on a false light, but with this client, with the death of a baby, we couldn't have asked for a better set of people to come forward for our client. Didn't need to be subpoenaed where they were there. Well, we had one that needed to be just to show our work. I had an excuse to not show up for work. But otherwise would not have needed one. They were there. They were invested. They cared for her. They stayed with her all the way through the end of punishment. We were talking about my 7 jury trials in the summer. This one started Monday, ended Tuesday the following week. And on that Tuesday, I was picking a jury. While we were waiting, the jury was deliberating punishment. They deliberated like 6 hours, 7 hours or something like that. And while that's happening, I'm picking a jury for my next trial for a continuous sexual abuse of a child, a guy who confessed for 3 hours of doing some heinous stuff. And so I think you have probably had the experience where those clients that are, have no redeemable qualities, we tell ourselves if we're not this, I'm not going to affect how we present to a jury or our motivations, but it kind of does in a way. We don't feel that same that gusto, that drive. But the state did their jury selection, and then we got the verdicts, and so we go upstairs, find out my client gets probation, and it could be any happier of a moment, and that really motivated me to do a very good job for this next one.
So Mary's case, what did this case teach you?
It taught me that, that initial view, like I read the case and I was like, this is horrible. I was very pessimistic about any chances of doing anything to move the needle. And as I got to know my client more, like that first interview was kind of that initial, not standoffish, but that kind of a little bit back and forth, building rapport and all of that. But like on the second meeting after I read the discovery, I didn't even talk about the discovery. Like I was going to talk about it, but I was just like, I just want to hear your side of things. And she opened up about all the stuff and the stuff in the interview. I honestly hadn't looked at the second interview. Well, it's not the second, the jail interview she gave. I read highlights, but of course, detectives write things down the way they want to, and it wasn't as strongly worded as was actually in that interview. And she talked about it, and I was like, okay, all right. It really kind of me to really look at things again, and to say that, on some cases, that initial read of a case, always be open. Like we talked about at the very beginning, like why did criminal offense? It's like really trying to find out what happened in something and find that truth behind the offense report and what else is going on. And this was kind of another reminder of that, to where, you can, and sometimes in our criminal defense, sometimes taking up the burden of proof, not taking up the burden of proof, but, proving the case better than the state can, sometimes could be better for your client. But then mitigation and punishment, I've always valued it, but I value it even more. My mitigation specialist, who I've not talked about, and I would be remiss if I didn't talk about her name is Shannon Ross. She's a mitigation specialist here in North Texas and does stuff all over the place. She's a personal friend of mine. She gives my daughter horseback riding lessons. We go over her house all the time. And in this case, Haley went over to Shannon's house a couple times. They became really good friends. And Shannon Ross has helped me out in so many cases, that understanding and appreciating mitigation and the empathy that you can have for your client, and if you get other people to buy into it, can do wonders. One of the things that we haven't talked about is the jurors in this case. Afterwards, we went to go talk. Always talk to your jurors. I don't care if you just got here after.
Win, lose, or draw. Talk to them.
Always talk. You will find out so much. And this one was so touchy. 3 of them handed Bible verses to us to give to our client. And I'm not very religious, to be honest. And the foreman of the jury, which was one that was like, okay, I don't know if you do this, like, if the 4th person comes out and it's one that you were like hoping it was, you're like, okay, this is gonna be better, this is gonna be good, And he was kind of on the fence, where I was like, okay, I'm not sure if he's on our side or if he's botching things. He was hard to read, but we knew he was a 4th person, guilt innocence. If we came around to punishment, we talked to him afterwards, and he said, yeah, after you did all your witnesses, I went home and I just read my Bible a bunch, and he like turned himself around, just doing the Bible study at home. And a couple of the jurors have stayed in touch with Shannon Ross, checking in on our client, who our client is still, like you talked about, clients checking in on you and stuff like that. I've had Haley call other clients of mine and just say, hey, we got a great attorney. Just do everything he tells you and all this other stuff. And I didn't know that a couple of times. The most recent one I had was a challenging aggravated sexual assault child case where it was a punishment case. So Shannon was on that one too. And my client called his family. They were so relieved and in helping out. So I learned that your initial view of the case could be completely wrong, and we had to be very our opinions don't matter as defense attorneys. It's what could be proven in court, right? And sometimes we need to appreciate that more even about ourselves and how that affects how we defend somebody, you know.
I always tell people that the longer you do this, the more you have to guard against becoming jaded. You really have to. There's times you'll hear a version and you're like, oh, this again. And then you're doing what the police do. You're doing what the prosecutor does. So you really have to guard against becoming jaded and look at every case as a fresh deal that you haven't encountered before, in order to really do justice, I believe.
100%. No, 100%. You know, I've had cases where I have a big grown man who's this big hulking, 6'6", got muscles I wish I had, this big guy, and he's charged with aggravated assault. And you're like, and of course, I'm just scared representing the guy. Didn't need weight.
I feel assaulted just him flexing.
Right, exactly. Yeah. And so this case I'm thinking of in my head, without going all in a long story about it, he cried like me. I met with him, and I was just like, I was touched by his response to the allegations, and I completely do things differently. He ended up being found not guilty on that. And my initial view though was like, this guy's cooked, and you just always have to be cognizant of, maybe you're wrong about a case. Because if you're wrong about it, then the state could be wrong. We know there are plenty of times that they're wrong, and we already know that, but sometimes our initial view of the case can be wrong in itself.
For the people out there in the Dallas area who may need you, where can they find you and connect with you?
Our firm does some social media stuff, and so we're on LinkedIn and Facebook. Our main number is 903-893-8177. We have an office up in Sherman, which is a little further north. There's a federal courthouse there, and we do a representation in North Texas and Dallas and Collin County. And so you can call us at that number, reach out to us at winsmithlaw.com, WYNNE Smith-Law.com, and always reach out to us. Even if you're going through an investigation or anything, we will help anybody out and give anybody advice. That's how you can get a hold of us, and we'll help you.